While the lawyers are moving, the next case is M.W.J. versus the Department of Children and Families. Excuse me. All right, the lawyers may begin. You may begin. I'm sorry, I'll talk loud.
Your Honors, this is a case that involves the termination of parental rights of a father to his two sons.
Could you give us your name, please?
My name is Diana Simpson from Ocala, Florida, and I represent the father in this matter.
Ma'am, can I ask you a question just to kind of break the ice here? Was the appellant required as a part of the case plan to comply with his probation?
Yes, sir. In fact, when this case started, the department already knew that he was on probation, and they made that a condition of the case plan.
All right. And did he violate his probation on?
Yes, he did.
How many times?
I would say at least twice.
Okay, now he's got nobody to blame for that but himself. Right?
I understand that, Your Honor, and in fact, that was a part of what I said in the brief was that the fact that he violated his probation, he did take that upon himself. However, even when people have gone to jail with case plans, the department under case law would still have an obligation to help to reunify the family. There have been cases where they have given case plans to inmates, even though he was the inmate was in prison.
Yeah, but they gave him the case plan. One of the components of that was he was supposed to comply with his probation. He violated. Now, doesn't that give the department at that point, once you violate a case plan, doesn't the department have a right to seek termination of parental rights?
Yes, sir. However, under part of the violation of probation was because he had lost his job. He worked, I believe it was the International House of Pancake.
Was that the only reason that he was violated?
I know he lost his job and he didn't pay his fines. And in fact, that was one of the things that we talked about. Part of it was financial. And in fact, that was one of the arguments that I made. He felt that...
But he was convicted of violating his probation, right?
Yes, sir. He went to prison.
Okay, but you know, in order to be convicted of violating your probation, if it's only financial terms, the judge has got to find that you didn't comply with your financial terms and that you had the ability to do it. So, I mean, doesn't that kind of undercut your argument there?
Well, the thing about that, Your Honor, is that sometimes they can take a best interest plea. And, you know, sometimes it's at the advice of their counsel where they will cut a deal with the state saying if you go ahead and do this, you'll receive so much time. Or so it's not necessarily that he may have said, I'm guilty of this or I consent to this. It may have been in his best interest to do it. I mean, I have seen these situations where that has occurred where, you know, sometimes they just want to go ahead and get everything over to have a clean slate.
But is that what happened here?
I couldn't say that because I didn't represent him in the criminal case.
Yeah.
The only thing that was before me was just the record that I had.
I mean, what did the trial judge that whose work we're reviewing, what did he have before him?
Okay, she had the fact that he had violated probation,
right,
that there was a batteries intervention course that was not paid for, and that the case plan was not done within a time frame.
Did she have before her that he had been adjudicated guilty of violating the probation? Was that conceded?
I believe that was in one of the judicial reviews, if I recall correctly.
Mm-hmm.
And so that was before the court.
Let me ask the question. Who was Geraldo Guzman?
He was one of the department's workers at the time. He I know he started out working with the department, and then with the different changes, they went to different agencies.
He testified, did he not, that separate and apart from the financial issues, that the father was not involved in the children's lives, that he would come and go, that he was given numbers to contact if you have a problem dealing with visitation or with finances, just to let us know and we'll work with you, and that he said his involvement, Mr. Guzman said the father's involvement was minimal. He did minimal things. He didn't contact the kids. He didn't contact the department.
If my memory serves me correctly, I believe that there was also testimony that he did visit the kids and that he was bonded with the children.
Well, isn't the test then for us if there was a basis in the record to support the judge's disposition?
Yes, sir, and I know that case law says that if there is a theory on which the court can base a determination, and that there's a presumption that the case comes to this court correctly. I understand that. However, the father's position is that he could not complete his case plan because he didn't have the finances.
What about the trial judge specifically found that he didn't believe that? He specifically found that he could have done it. Finances were not the problem, right?
The court found that, but there was also testimony from the defendant that he was felt as though he was backed into a corner, making choices to financially meet the obligations of his criminal case and to meet the obligations of this determination case. And his reasoning was that he was trying to stay out of jail, but obviously he didn't, because he ended up not meeting the financial obligations under either case. And basically his argument to the court was that I didn't have any money and the department didn't assist me, and under 39.61E, lack of finances, if that is proved before the court, could serve as a basis for not terminating a parent's rights.
I agree with you, but under paragraph 3, the judge specifically finds that he did not do things that he could have done. He was not prevented from doing things. It says that the father did not keep in touch. He had long absences. He had the ability to do some things which he did not do. And his case plan task was not the result of financial inability or DCS's failure to provide services. And then he goes on to say he finds the father's story incredible. So that's what the judge wrote, which means that's the basis, or one of the bases for termination. So how is it that you want us to overlook the judge's precise findings, not on economic issues, but on case plan issues, visitation, contact with the department, in essence failing to comply with the plan that he agreed he could comply?
Well, Your Honor, from the beginning, as I said, the department was aware that this man was on probation and that there were financial obligations. I understand what the court is saying. I understand that there is a presumption of correctness that comes with from the lower court. However, still under 39.806.1E, there are two defenses if the court terminates your rights under that particular statute, and one is your financial ability to comply with the case plan. And that is what the father argues, is that he did not have the financial ability to comply.
Do you have anything else?
No, sir.
Thank you. You have rebuttal time of about 11 and a half minutes.
May it please the Court, I'm Ralph McMurphy on behalf of the Department of Children and Families. And I will try to be very brief this morning. It's the Department's position that the trial court was completely correct on the evidence that she found credible in determining that parental rights could be terminated on the basis of failure to complete a case plan. And it wasn't because of finances or because he was incarcerated. The reason he was incarcerated was because he violated the case plan in the first place by violating probation. So you can't use as an excuse that I couldn't complete the rest of my case plan because I've already violated it and got myself incarcerated. That basically is a ridiculous argument. And as the court noted, he couldn't also say that I had to support my children, therefore I couldn't pay my fines, because he didn't support his children in the first place. He didn't pay his fines either. So the money that the court talked about him making at International House of Pancakes and then in construction jobs, it went somewhere, but it wasn't to either support his children or to comply with his probation and pay the fines and criminal court costs, which resulted in him getting incarcerated again and therefore violating the case plan. So that on the basis of all the cases that this court has repeatedly said that the standard of review is, such as LF and CC versus the department, there is no basis for overturning this case where this decision where the trial court's findings are supported by competent substantial evidence. Thank you.
Do you have anything you want to add now?
I know the court asked me a question about Mr. Guzman. And just basically from looking at the court said that my client did not have contact with Mr. Guzman. And maybe unless I read it wrong, he had contact with Mr. Guzman over 11 months and saw him on a monthly basis. But and that he did stay in contact with him. So I know that the court had a question about that, and I just wanted to clarify. I thought that he did actually have contact with Mr. Guzman, and that there was contact between the father and the child.
Thank you, ma'am.
Questions or recess?